Good afternoon, everyone. My name is Julian Morse. I'm the MLA for Frame Lake and chair of this committee. Today, committee continues its review of Bill 26, an act to amend the Public Service Act. This public briefing is being live streamed on the Assembly's social media channels. As a reminder, please direct all comments and questions through the chair, and please wait to be recognized and for your mics to be turned on before speaking. This helps keep the meeting running smoothly. So I'm going to ask members to introduce themselves. I'll start with Mr. Rogers on my right.
Thank you, Mr. Chair. My name is Denny Rogers. I'm the MLA for Nuvik Boot Lake, and welcome everyone.
Good afternoon. I'm Kate Reed. I'm the MLA for Great Slave. Thank you for joining us today.
Greetings and salutations, everyone. I'm Robert Hawkins, MLA for Yellowknife Center, and as always, I'm happy to be here along with our millions of subscribers on the Legislative Assembly's social media. Thank you.
Okay, thank you. And we have one member online, Mr. Jericon, if you want to go ahead.
Thank you, Mr. Chairman. I just want to thank everybody for being here today. And my name is Richard Jericho for MLA Trinity Validity. Thank you.
Excellent. Thank you, everybody. So this morning, committee, or this afternoon, I should say, committee is pleased to welcome Josée-Anne Spirito, Regional Executive Vice President, North of the Public Service Alliance of Canada. She is joined by Legal Officer Shannon Blatt and Regional Political Communications Officer Aaron Manton, but I'm not seeing them next to you, so, okay. Thank you very much for joining us, Ms. Spirito. I'm going to turn the floor over to you for your opening remarks and presentation. As I'm sure you're aware, we'll then open the floor up to MLAs for questions. So the floor is yours.
Thank you, Mr. Chair. Can I just ask if our technical advisor who is joining online, has been allowed to join?
That's Shannon Blatt. It does appear that she's
Perfect.
online, yes.
Take I just wanted to confirm that they had been.
Oh, I got a radio face, but I'm just trying to get the slides to go. There we go.
Well, good afternoon. Thank you, Mr. Chair. I want to start by thanking the committee. Thank you for taking the time to hear from us. Really appreciate your time this afternoon. As mentioned, I am Josée-Anne Spirito, Regional Executive Vice President for PSAC North. I'm joined today by PSAC North Regional Communications Officer Aaron Manton and PSAC Legals Officer Shannon Blatt, which will be appearing remotely as a technical advisor. I will begin by explaining my role in the union and the labor movement and how that informs the issues that I will be speaking to today. Like all of you, I'm here to represent the best interests of my constituents. As Regional Executive Vice President, or REVP, for the North Region, I represent members in all three territories of on the Public Service Alliance Executive Committee and our National Board of Directors. This is my first three-year term in this role, which I was elected to by fellow members at the PSAC North Regional Triennial Convention in May of 2023. I'm not only an elected leader in our movement, but I'm also a healthcare worker and a proud union member since 2013. My labor movement activism began on the executive of Local 33, made up of NTHSSA workers in the Sambake region, where I sat on numerous bargaining teams with the GNWT. I also served as second vice president of the Union of Northern Workers prior to being in my current role. To this day, I am actively practicing as a licensed practical nurse here in Yellowknife, my home, for more than 15 years. In fact, my last shift was just 2 days ago, as I worked regularly to maintain my license. I hear from workers and patients regularly, both in my role as a nurse and in my capacity as REVP. I know the challenges facing healthcare workers in the North because I have lived them. I have fought alongside fellow workers to improve our working conditions, first at the grassroots workplace level, and now at the national level. I'm going to tell you a little bit more now about the PSAC. The Public Service Alliance of Canada, commonly referred to as PSAC, is one of the largest unions in our country, representing 240,000 members in every province and territory. We are a democratic organization, which means the union is the members and the members are the union. Our members work for federal and territorial government, departments and agencies, crown corporations, universities, casinos, Indigenous community and First Nations police, housing authorities, power corporations, mines, airport, firefighting, corrections, security, and of course in healthcare and countless other workforces. PSAC is quite literally a very large union made up of unions consisting of 15 component unions that bring together members in similar fields, regions, or jurisdictions. These include many unions like the Agriculture Union, Custom and Immigration Union, the Union of Canadian Transportation Employees, the Union of National Defense Employees, and the Union of Taxation Employees, among others. Of course, the component you're certainly more familiar with, the Union of Northern Workers, or the UNW, represent members in a wide range of workplaces across the Northwest Territories. In addition of the component structure, PSAC is organized into 7 regions: the North, British Columbia, Prairies, Ontario, the National Capital Region, Quebec, and the Atlantic. Our staff, over 400 strong, work in 8 branches and sub-programs with expertise like human resources, law, research, bargaining, finance, information technology, organizing, mobilization, communications, education, and human rights. PSAC has 23 regional offices across Canada, including one in Whitehorse, one in Iqaluit, and one here in Yellowknife. In fact, as the only public sector union with boots on the ground in the territories and more than 20,000 members in the Yukon, Northwest Territories, and Nunavut, we are proud to call ourselves the Union of the North. While it is typical for other public and private sector unions to group northern workers into southern employee groups, with, for example, NWT members often serviced by staff in Edmonton, when PSAC members in Yellowknife need support of their union, they can call or visit an office in Yellowknife or a component office in their own community and speak with staff who are familiar with their community, their way of life, and the unique challenges that they face. And when PSAC members in the Northwest Territories begin a new round of collective bargaining, they have support of lawyers, negotiators, and researchers that are based in the North, drawing on intimate familiarity with this region's labor relations landscape. I'm now going to talk to you a little bit more about the bargaining process. As you know, the NWT Public Service Act sets out the formal bargaining relationship between unions and the government of the Northwest Territories. The Act defines and categorizes employees, including which are unionized or excluded, sets certain terms and conditions of employment, and outlines how disputes are dealt with, how essential service agreements are devised, and workers' rights around strikes. But members are at the center of the process and take part in all aspects of collective bargaining, from providing and reviewing input to the ratification of tentative agreements. PSAC's constitution, a document established democratically by union members, contains specific regulation, 15B, that govern collective bargaining for members employed by the GNWT. Regulation 15B sets out the roles of members, locals, the UNW component, and union executives like myself in the bargaining process. The PSAC's elected National Board of Directors, made up by REVPs like me and component president like UNW's Gayla Thunstrom, also has a role in setting bargaining and strike strategies for the union. The whole process is designed to empower workers to become involved in bargaining for the betterment of all members. At the beginning of each round of collective bargaining between UNW members and the GNWT, a call goes out from the UNW to executive and local presidents, giving notice to seek bargaining input from members, and guidance is provided to locals on how to develop effective and impactful proposals. Each affected local is required to form a local-level bargaining committee that collects and prioritizes proposals before sending them on to the UNW executive, which will review and submit these proposals before they are presented to a larger group of members through the GNWT Bargaining Conference. Delegates to the bargaining conference, elected at the local level by fellow members, review and discuss proposals before prioritizing those they wish to see brought to the bargaining table. Delegates then elect a bargaining team who will finalize bargaining proposals for inclusion in a bargaining package that will be submitted to GNWT for negotiations. In addition to the 6 local members elected at the bargaining conference and alternates, the bargaining team is supported by the UNW president and PSAC technical support staff, typically a negotiator and a research officer. Bargaining team members represent the membership during every phase of the negotiations process, making decisions about which proposals to pursue. They collaborate in crafting communication that inform members about the status of negotiations. They stay involved during bargaining disputes, mediation, or conciliation, and they support tentative agreements reached and help explain agreements to the membership prior to any votes. The structure of bargaining teams ensure that all geographic region in the NWT, all occupational groups, and equity groups like Indigenous members are given a meaningful voice in this process. At the most recent GNWT bargaining conference held last month in Yellowknife, 2 nurses from Local 11, Stanton Hospital workers, were elected to their bargaining teams. In addition to arbitrated wins such as improvements to labor market supplements in previous rounds of negotiations, our structure has allowed for critical issues for nurses and other healthcare workers to be brought forward to the employer. GNWT bargaining teams have made numerous proposals in previous rounds that benefit all members: improvements to various leave, annual compensations, increases, improved hours of work, and more. Some of the proposals that have addressed issues raised by GNWT healthcare workers over the last 20 years include compensation for employees that must work a scheduled shift after being called back or reporting for work while on standby, improvements to overtime compensation and carryover of offsetting time, conversion of term employees to indeterminate after 2 years, limiting contracting out of work, language on harassment, abuse of authority, and workplace violence, including the Professional Development Initiative for healthcare workers into the collective agreement, improved compensation and protection for casual employees, and centering reconciliation and culturally appropriate care as guiding principles of our healthcare system. Often, proposals such as, for example, Indigenous cultural leave must be brought to the bargaining table over and over and over again, as the employer rarely says yes to the proposals we initially bring forward. But as we like to say in the labor movement, when workers fight together, we win together. And so through the strength of solidarity, we have been able to achieve significant gains for healthcare workers that cover issues from health and safety to better compensation. These include a review of issues related to health and safety for employee rest periods between shifts, a review of work alone standards, carryover provisions for the statutory holiday bank, improvement to allowances for clothing and laundry, improving to offsetting leave and leave bank for midwives, numerous additional health and social services positions being made eligible for labor market supplement, and a labor market supplement in communities now ranging from $10,000 to $12,000. In a mature collective agreement that has been steadily built over decades of bargaining, this is how progress is normally made. That is, gradual improvements over time agreed to over several rounds of negotiations. Proponents of Bill 26 have told this committee that workers start from scratch and the beginning of each round of bargaining, but nothing could be further from the truth. The current collective agreement between the GNWT and its employees is 241 pages long and more than 50 years in the making. As you can see, it is a substantial document holding decades of hard-fought gains. However, if nurses were to become represented by another bargaining agent, they would have to fight to retain their existing provision along with any improvement in any new agreement, with no guarantee that they would be successful on either account. In negotiating their first agreement, they would risk losing the terms and conditions of employment that have been bargained over the years. Without an existing collective agreement, everything becomes subject to the new negotiations with the GNWT, and any measures not legally required would not be guaranteed to be part of the new agreement. Bill 26 would literally make the existing collective agreement disappear. Everything would be on the table, and as a primarily essential workforce with no access to arbitration, nurses would have very little bargaining strength to leverage in maintaining their long and hard-fought gains. Bill 26 would put workers at the mercy of their employer, forcing them to truly start from scratch. While the issues the bill seeks to address are serious, the bill in itself, with respect, is not serious. It's inadequate and frankly irresponsible. Certification processes operate in a very complex adversarial legal environment with legislation, regulations, and policies designed to protect all stakeholders involved, the employer, the union, and most importantly, workers and the public. Certification is also just one aspect of the legal framework governing labor regimes related to and mutually dependent with other aspects. As such, any changes to labor law must be carefully balanced to maintain protections for employers, unions, and workers. Major overhauls to labor legislation are almost always carried out by expert, highly experienced labor relations professionals that are typically lawyers. Consider this. If you were going to make changes to the structural load-bearing beams of a hospital, you would likely want an expert in architecture to make sure nurses and their patients are being protected. As you know, the labor relations framework for employees of the GNWT is, in fact, already being reviewed within the purview of modernizing the Public Service Act. This review is being done carefully in a balanced way that doesn't put the various stakeholders at risk. It is being done the right way. Bill 26, however, lacks the requisite details, safeguards, and precision required when overhauling such a significant element of labor law. Put another way, Bill 26 proposes to rip key load-bearing beams from the NWT's labor relations framework with little regards for the employers, unions, workers, and of course members of the public that it should protect. Instead of recognizing the reality that certification processes are complex for a reason, this bill would introduce a level of disruption and uncertainty that simply would not serve the interests of nurses or any impacted workers. We do understand the proponent's intent, but there's a difference between the spirit and the letter of the law. And in this case, the letter of the law does the exact opposite of the spirit by putting stakeholders at risk. The bare-bones certification process outlined in Bill 26 stands in stark contrast to labor codes across Canada, which establish substantive and lengthy frameworks based on decades of experience and precedents, setting out how union can be certified to represent or cease to represent employees in collective bargaining. Some labor boards in Canada have certification processes that can be over 10 pages long. To describe outlining how certification can be conducted democratically and how concerns with or objections to certifications can be heard and dealt with fairly, and addressing the various important sub-issues that form part of any responsible certification process. Labor boards across Canada have specific rules around voting, developed based on years of experience administrating contentious certification votes. In contrast, Bill 26 lacks provision for third-party monitoring of certification votes that we would typically see in other jurisdictions with neutral decision makers ensuring everyone is heard. Absent these common provisions, Bill 26 would be an outlier in leaving this to the applicant alone. In practical terms, this means that an association seeking to represent workers is put in the dangerous role of making key determination about the fairness and integrity of their own process. Any decertification process with a union ceasing to represent workers would suffer the same pitfalls. Bill 26, therefore, invites self-dealing, contravening the legal principle that no one should be the judge in their own cause. While processes in other jurisdictions are designed to prevent manipulations in the certification voting process, Bill 26 creates conditions for abuse and would have foxes in charge of protecting the henhouse by putting certification applicants in the position of ensuring fair process. Let me be clear. There will be manipulated votes in a system that allows for them and creates opportunities for them. Bill 26 proposed introducing a certification process into an act that doesn't presently have one, something that, if done, needs to be done the right way to protect all those involved. However, Bill 26 isn't written to do these things right. It is written to make things worse. That's why PSAC has asked a neutral expert, arbitrator Vince Reddy, to provide an analysis of the draft legislation. This is a renowned labor law specialist, trusted by unions and employers both, who has committed his professional life to ensuring a healthy, functional collective bargaining system across our country. Arbitrator Reddy is both eminent and impartial, as much as can be found in Canada, and we asked for his honest, objective opinion. His findings in the document that I will be tabling for this committee's consideration today loudly sound the alarm about the bill's potential harms. Given the inherent flaws I've described, there are countless very realistic scenarios that illustrate how employers, unions, workers, and the public would be vulnerable if Bill 26 was to be implemented. According to the bill, to authorize a bargaining agent for nurses, the court must be satisfied that there was a vote conducted in which all nurses in the public service had had an opportunity to vote. So if just one nurse was determined to have been denied the opportunity to vote, should the court deny the application? The language in Bill 26 seems to suggest this. And what about quorum? If only 10 nurses participated in such a vote, should this be considered an expression of the workforce's true wishes for representation? Under Bill 26 provisions, it would be sufficient. How will an applicant or a judge know where to draw the line on deciding whether a nurse is in the public service and thus eligible to vote? Can a nurse with management responsibilities vote? What about a nurse in long-term disability or someone who hasn't worked in the Northwest Territories in years? Should a nurse on maternity leave be allowed to vote? What about a nurse that has no intention of ever returning to the North to work again? This bill provides no guidelines or standard that would ensure people with legitimate interest in the outcome are making the important decision of who should be the bargaining agent for nurses. For nurses whose wishes should be reflected by a vote, how should they prove their eligibility to participate to the applicant? If, as Bill 26 allows, the union seeking to be certified will make these decisions with no oversight, can we assume the highest standard would be followed? Should we be comfortable with unreliable and fundamentally undemocratic outcomes? Who decides when, where, and via which format the vote should take place? Who determines how long voting is open for? Who is responsible for counting the votes? Should there be a scrutiny process? With no secret ballot provisions, the norm in other jurisdictions, would electioneering, peer pressure, and intimidation in workplaces be permissible? If the employer supported a particular association trying to organize in a workplace, should nurses expect threats and consequences if they express their genuine wishes? If there are allegations of mischief or inappropriateness in these areas or at any point in the voting process, how should they be raised and to whom? The way the bill is drafted, all of this will be up to the association hoping to represent nurses. Even if concerns are brought to the attention of the court, what should the court do? What happens if two associations apply and both can satisfy the majority vote requirement? How should the court decide with no guidance in legislation or regulation? This bill does not contemplate any mechanism to resolve any of these questions. But we know that at least some of these questions will come up at any vote that occurs, because we have seen these issues very commonly everywhere across our country. I ask you to consider this. Would it be acceptable if an association held an electronic vote that was open for 10 minutes, so long as all nurses, theoretically, had a chance to vote in it? If those without stable internet access could not participate, if the vote were not widely publicized or accessible, if only 10 nurses in a workforce of hundreds participated. In a world where Bill 26 was implemented, such a vote could satisfy the requirement to certify a bargaining agent and impact the future of nursing in the Northwest Territories. The language in Bill 26 allows for a nurses' association to be displaced 6 months after the association is first granted the right to bargain on behalf of nurses. This means that 6 months after voting in favor of a bargaining agent, workplace organizing to certify a different competitor bargaining agent or decertify the existing one could begin anew. Given the opportunity for employer involvement in union busting and decertification campaigns, nurses would be at an ongoing risk of losing union representation entirely. Whether through decertification or union raiding, a continuous fight between associations vying to represent nurses would undoubtedly have a negative impact not only on nurses themselves, but on the public who rely upon nurses for healthcare. because the lack of controls for certification would hold the door open for rating and decertification as well, on the same low standards, with the same lack of basic procedural safeguards, the risk of nurses losing their collective agreement entirely would be relentless. Remember, we don't start from scratch each round of bargaining, but under Bill 26, a collective agreement would evaporate each time a new bargaining agent is certified. Proponents of the bill have stated repeatedly that the existing collective agreement would remain in place for nurses even after a new bargaining agent has been authorized. They have also said that UNW would be legally obligated to continue enforcing the agreement and servicing members even after a new bargaining agent has been authorized. Both of these statements, quite simply, are not true. It is clear from the text in the bill, specifically in its amendment to Section 4104, to add a new subsection 3, that the current collective agreement would not transition over to a new bargaining unit. Instead, the terms and conditions of employment applicable to nurses are frozen in place during the period in which their new bargaining agent negotiates a first agreement. It is not the same thing as continuing a collective agreement. In our reading of the bill, if a new bargaining agent were authorized by the court, they would be the exclusive bargaining agent. That means UNW would not be required to continue to act as a bargaining agent, and in fact, probably not even permitted to do so. Despite what may have been intended, Bill 26 would not do many of the things its proponents have claimed it will. The serious concerns I have raised are not based on assumptions. They are issues based on in-depth and precise consideration of this bill's text and its wide-ranging ramifications, and they are reinforced by the conclusions of Arbitrator Reddy's report. I want to emphasize the neutrality of this advice. PSAC did not ask for a report that tells us what we want to hear, because we already know how we feel about this bill. Given that reforms of this scale to legislation of this importance for workers need to be done carefully and systematically, you and your constituent deserve the benefits of this expert analysis. The architecture of Bill 26 is inadequate to the extent that, put simply, is dangerous to all stakeholders, not least amongst them nurses. Contrary to claims that voting against this bill is voting against nurses, I really encourage you to use your position in this committee to support nurses and to protect our healthcare system by ensuring that changes like these are done the right way. While doubtlessly well-intentioned, Bill 26 has the potential to put nurses in a precarious and vulnerable position. This is not in the best interest of nurses, of our healthcare system, or of families and communities in the Northwest Territories. Thank you.
Okay, thank you very much for the presentation. Going to committee members for questions now. I have Mr. Hawkins first. Oh, actually, before we get started, just does committee have a preference as to whether we do time comments? Do you want to do a series of questions or just two each and keep going through rounds?
Just on that point.
Sure, Mr. Hawkins.
Yeah, I mean, it's such a small group here today, it's not, so maybe two is fine, and then we can just keep things moving.
Okay.
If it was a large group, time probably makes sense to keep things going. So,
Seeing no concerns with that, two questions, Mr.
it's a small
Hawkins.
group.
Starting with the first.
Thank you. Yeah, that wasn't one word, was it? Okay, thank you very much. I want to appreciate, let the presenter know I appreciate how detailed the presentation was. I was just sort of flipping through Mr. Reddy's comments here, and I want to read it cover to cover in an environment I can absorb it better. So I'll just say for the, first off, I believe we can append it to our final outcome. That'll be a committee debate later, but I'm sure several of us, if not all of us, agree that if this is submitted material on the record, there's no reason why it shouldn't be included in our reports for consideration. I notice how he talks about postponing, basically talks about the challenges here and more review mechanisms, and given the totality of the things you had just said, I mean, it is so complicated. You have to be a really, you almost have to be a surgeon to figure out how to navigate this system. And hence, taking one brick of process out is not the game of Jenga. It's, whereas in, things can work for a while. I worry about how quickly things will tumble. If I can ask you to revisit before, I've got a couple questions, but if I could ask you to revisit first, maybe just more of in a bullet point sense that I'm hearing structure, rules, safeguards, and transparency become a true risk by going forward with Bill 26. Could you reiterate or re-explain maybe in a short way of condensing your presentation to say, would there be risks on day one? Would there be fears of process moving forward? I'm just concerned about the frustration of this whole process, that the nurses will be going backwards, not forwards. Do you appreciate where I'm asking about what risks they'll be taking on if Bill 26 was proceeded with? Thank you.
Thank you. Ms. Spirito?
Thank you, Mr. Chair. I'll do my best. I think that the largest risk in our assessment at PSAC is that although nurses have been reassured and other healthcare workers have been reassured that the collective agreement would remain in place, it's actually not the fact. There's a difference between having a collective agreement and enjoying everything in a collective agreement and terms of conditions of employment being frozen, which is what exactly Section 4104 subsection 3 is doing. So I think that is the largest risk, is when we start a round of negotiation, we amend the text that is already contained in a collective agreement. We start from this collective agreement, which is 50 years in the making. Starting from nothing, everything would be considered a new proposal. And I'm not sure if I'm capturing the question, but I'm hoping this is what I would identify as the largest risk.
Okay, thank you. Mr. Hawkins, follow-up?
No, I appreciate that. In some ways you are. I mean, we could probably be here another hour going through every risk, and I'm just trying to, I want to know what I'm agreeing to before I agree to it. I hope, I have no doubt, but I'll just liken it to your industry. Before you give someone a pill to say, swallow this, it also comes with, this is what it's treating, but this is the risk it comes with, right? So it's like this bill, we also have to appreciate what they're trying to do, but we also have to appreciate the risk they're creating or the ripple effect they're creating. So that's what I was trying to ask you, which was, what are the risks that potentially could be taken on? And I was hoping to sort of get it to a sharp tip. Mr. Chairman, just quickly, my next question is really built around, my understanding the Yukon Labor Board had some challenges and through their process, and I'm wondering if our witness has some experience or could elaborate a little further on that particular detail, or perhaps maybe her team can help us understand the risks of taking this new journey forward. Thank you.
Thank you. Ms. Spirito?
Mr. Chair, if that's okay, I'd like to go to the technical advisor that we have online, Shannon Blatt. They are labor lawyers and could probably explain. We represent the members of the PSAC in Yukon and have had some dealings with the labor board there, and Shannon is probably in a good position to describe some of the challenges we've seen.
Okay, Mr. Blatt?
Thank you very much. It's Ms. Blatt. I'm a transgender woman. She or they are my pronouns. Thank you very much. I won't go into too much depth on this, except to say that early in 2025, there was a crisis. Actually, I think the Yukon was hurtling towards a crisis. There was a dispute between the government of the Yukon and the Federal Public Sector Labor Relations and Employment Board, which is the tribunal that administers federal public sector labor relations, but also wears a separate hat of sitting as the Yukon Public Service Labor Relations Board. It was, I believe, a dispute about administrative support and resources, and it culminated in the chair, Ms. Edith Bramwell of the federal FPSLRBB, actually threatening to cease providing all services in the capacity of the YPSLRB, effective, I believe it was April 1st of this year. I believe that crisis was averted, but it was a very serious issue, and I think probably some lessons learned and caution taken by the Yukon Territory in that case. I would also suggest that one of the downsides of that particular board is the fact that it's based in Ottawa and staffed by the same individuals and adjudicators who chair the board that governs and administers the federal public sector labor relations legislation. It's not territorially based. It's not territorially reflective. And it's basically a group of Ottawa insiders, connected individuals and lawyers who do a fine job, but are not of the Yukon. I think I don't speak out of turn in saying that the PSAC would prefer to see a labor board for the NWT that is of the NWT and reflective of and representative of. I hope that has answered the question.
Okay, thank you very much, Ms. Blatt, and apologies there, sorry, and thank you for the correction.
Oh, not at all.
Ms.
Not at all.
Spirito, did you have further?
I think,
Comment?
if that's okay, Mr. Chair?
Yep.
I'll just add quickly that I think the biggest challenge is that when there are disputes between the Yukon and this federal labor board, we were sent a letter one day and we were told that there may not be a labor board anymore with 3 months' notice because of a dispute between the Yukon and federal labor board. And that means nobody to oversee strike votes, nobody to resolve any type of disputes. So I will say that, the root of the issue is one thing, but the impact that it could have had on workers in the Yukon is what our main concern was at the time.
Thank you very much. I have Ms. Reed next for questions.
Thank you, Mr. Chair. Could you go to the next question? I just want to pull up the document and make sure I'm accurate. Thank you. Come
By
back
all
to-
means, Mr. Rogers, you're up.
Thank you, and thank you for the presentation. Certainly for those of us who haven't been, I guess, delved deep into the world of unions, it's certainly a learning experience. We certainly appreciate that. Getting some more detailed information on how the system works. And as a government, I mean, you represent your union workers. We represent every citizen of the Northwest Territory, and certainly, I think our goals are the same. I mean, we have a government to run and a limited budget, and we have to find ways that we can do that and still maintain and keep our system going the best it can. We know there's a struggle across the country with healthcare, particularly with nurses, not only our jurisdiction but others as well. So certainly appreciate that. One of the questions I had, and I think was brought up in a previous presentation we had, perhaps from UNW, was the fact that, I have a question on the Labour Board as well, but if, as in other jurisdictions, I think Saskatchewan, Alberta, BC have all had some success with union, nurses having their own bargaining unit. I know there was some growing pains early on, but they did succeed in increasing wages and other benefits. One of the concerns was, well, if the nurses have a smaller bargaining unit, then they won't have as much, or as much power to be able to negotiate. The other side of that, what would you say, well, if they were a smaller group, would that not give them a better opportunity to kind of negotiate and to get things other, and it's not just wages. I realize that we are, if you add our northern allowance, I think one of the presentations we got said we are on par with our southern counterparts for wages, but there's more than just wages, obviously at times, to attract people to come and live in our amazing territory. We all love living here, but oftentimes it does take certain adventurous individuals to come and live in the smaller communities and different regions. So I guess what would you say to the fact that if it was at their own bargaining unit, at a smaller unit, that would actually give them an advantage, whereas they wouldn't have everything they negotiate would then have to be, I guess, throughout the whole entire union force rather than just their specific group? Thank you, Mr. Chair.
Thank you. Ms. Spirito.
Thank you, Mr. Chair. That's quite the question. I think the debate on whether or not nurses having their own collective agreement is its own debate, in my opinion. And as a nurse, I have, of course, I'm very interested, and as a labor activist, I'm doubly excited about the debate. But at the end of the day, it will be up to nurses to make that decision, and there are a list of pros and a list of cons, I believe. Where we fall on the topic is one thing, but if this is the direction that we are going into, to give nurses an opportunity to make that decision, I truly believe that it needs to be done in a way that will be cautious enough to ensure that their interests are protected throughout that process. After reviewing this bill just simply does not achieve that, and that's where we are really concerned. In fact, we feel that it opens the door to many other challenges that nurses could be facing because of the way it's written and what it brings into legislation. So, it's a very good question. yes, there are pros and cons. We could have part of that debate here today and discuss this, but at the end of the day, I truly believe that that decision should be made by the nurses of the Northwest Territories or the healthcare workers of this territory.
Okay, thank you. Mr. Rogers, do you have a follow-up?
Thank you, Mr. Chair. So then, in the in what work has been done so far, and I guess in what, negotiations will be ongoing, obviously, but with Bill 41 then, and with the contemplation of a labor board, what is the PSAC's opinion on that? Do you think, obviously, sorry?
There's no Bill 41.
Sorry. I think Ms. Blatt had mentioned that PSAC would welcome a labor board. Do you think that is the answer to be able to then move forward and have a separate bargaining unit for nurses?
Okay, thank you. Is that question clear, Ms. Spirito? Yeah.
Yes.
Okay.
I believe what Shannon described is that PSCC would be supportive of having an NWT-based labor board as opposed to an Ottawa-based labor board. So just clarifying that first, PSCC would not be opposed to a labor board. And is that one of the avenues we need to explore while we have that phase 2 discussion about section 41? Absolutely, we need to have that conversation. And what I can say is that we wouldn't be opposed to having a labor board. I hope that answers the question, Mr. Chair.
Okay, thank you. Back to Ms. Reid now for questions, if you're ready.
Yes, thank you, Mr. Chair, and thank you for your patience, and thank you for going ahead of me, Mr. Rogers. I just wanted to pull up the member's bill, so I read it verbatim because I think it's important to do so. So in the private member's bill, there is section 6, brackets 3, which reads, "For greater certainty, any term or condition of employment that applies to nurses who are members of the Union of Northern Workers continues to apply until a collective agreement is entered into by an employees' association that bargains on behalf of nurses." So that is the language that's captured in the private member's bill. Today, Ms. Spirito, you said things like the CA could evaporate, the terms could freeze in time. So we've heard conflicting opinions from yourself, the sponsor of the bill, and others on what would happen for nurses with their current collective agreement should this bill be passed, and if a new bargaining agent was certified by the NWT Supreme Court, which is contemplated by this bill as well. So I'm wondering if you or your legal advisor who's on the line could clarify from a legal perspective a little bit more about what we've discussed earlier. Mr. Hawkins brought it up as well. Can we put into plain language what it means with this bill, what happens to nurses, but not only their collective agreement and their rights captured or frozen in time, I think you said, and what happens in the interim as in theory, I guess, if a new agreement is being bargained. Thank you, Mr. Chair.
Thank you. Ms. Spirito for response.
If that's okay, Mr. Chair, can we start with Shannon for a response?
Of course. Ms. Blatt?
Hi, thank you. So I think when you read that provision 6.3 of Bill 26, it's important to read it against the Act as it currently reads. And so it's an amendment to section 41.04. And if you look at section 41.04, you'll see that it's about what happens at the period of where a collective agreement is about to expire. It's called a freeze provision. And this is standard in labor legislation. And the purpose of this provision is that when the parties are ready to bargain a new collective agreement, the legislation imposes a freeze on the terms and conditions of employment. And that provides a stable foundation from which the parties can then bargain their new agreement, however long that may take. To me, as a labor lawyer of nearly 26 years experience, that is a freeze provision. that's being added to the freeze provision of the Act, where legislation wants a collective agreement to remain in force or transition to a new bargaining unit or a new employer in cases where new government agencies are created or there's been a sale of a business to a new employer. It says so. It uses that language, but you'll see that Section 6.3 of the bill does not use that language. It, for the most part, reads as a standard freeze provision that keeps the terms and conditions in place while the new bargaining agent for the separate bargaining unit of nurses bargains a first agreement. And it will keep those in place until a new bargaining agent for a separate bargaining unit of nurses has successfully negotiated a first agreement. So it's a protective provision for nurses, and it's a conventional, fairly standard, well, completely standard thing to have in labor legislation. But my understanding is that there have been some conflicting statements out there, perhaps I think reflecting some good faith misunderstanding about exactly what that provision will do and be found to do by a court that interprets it. Because I have no doubt in saying it will not be found to keep a collective agreement in force. It will be found to be a freeze condition provision that keeps terms and conditions in force. And that is an important distinction. And related to this is, well, who will be responsible for enforcing those frozen terms and conditions? If a new union has been certified, or as the language of the bill would have it, authorized to act as the new bargaining agent, they will be the exclusive bargaining agent. They will be responsible for enforcing those frozen terms and conditions. Nurses will have moved out of the general GNWT bargaining unit into a separate bargaining unit, still employed by the GNWT, now subject to frozen terms and conditions and no longer under the ambit of the pre-existing collective agreement. Does that answer your question? And I'm happy to clarify further.
Thank you. Ms. Reed, do you have a follow-up?
You're welcome.
I think so, and I just, perhaps I'll say my understanding then, and please correct me if I'm wrong, that means that the UNW ceases to be a part of the equation and this new agent takes over. Is that correct? Thank you.
Thank you. Ms. Blatt?
Yes. Yes, I believe that is exactly correct.
Okay, thank you. There's more of a clarifying question. Ms. Reed, did you have a more substantive follow-up on this round, or?
More of a comment, but if you don't mind. Yeah. So, as Ms. Spirito, you know, I have a great personal respect for Mr. Reddy. The events of 2019 that introduced you to me were, the temperature was brought down quite a bit by Mr. Reddy, and he found a way forward for employees of the public service and the employer to move forward without a strike. It was a very emotional time for a lot of folks. It's why I got involved in labor to begin with. So I appreciate very much that PSAC went forward and sought this opinion. I will have to digest it later. Obviously, we did not have a lot of time to read this. One thing I would say, thinking about this and thinking about that experience, what you said earlier about nurses are the ones who have the voice to whether or not they go down this road of having a separate bargaining agent. I could not agree more. I've said that since day one in my comments. Could you speak to your experience broadly? Obviously, it's a confidential experience, but bargaining with this employer, do you believe, and this is conjecture, I understand, that a separate bargaining unit would find more success in applying for further gains through the collective bargaining experience with this employer in a way that's contemplated as a separate union for nurses. Insofar as I recognize you're a nurse, I recognize you've been involved in labor unit, in the labor struggles for GNWT nurses for some time now. What has been your general read on this employer and trying to find specific allowances, be it wages or otherwise, for nurses? Thank you, Mr. Chair.
Okay, thank you. Ms. Spirito, do you have a response to that comment?
Yes, please. I want to thank the member for acknowledging Mr. Reddy's wide experience into the labor movement and his contribution to both unions and employers in terms of finding grounds to make deals work across this country, and is arbitrator. He's been an arbitrator, mediator, conciliator, and has in the labor dispute that we saw between at the GNWT in 2018 and 19 ended with Mr. Reddy being the mediator assigned to this specific file and helping us get a deal hours before a strike was going to start. So, and I think it speaks of his commitment to fairness and his sort of the way he is able to bring a neutral perspective. So thank you. I want to thank the member for bringing this forward. About the success of a bargaining unit with this specific employer. Again, we go a little bit more into my opinions. I like to stick to facts. I'm a very factual person when I can be, but bargaining with this employer is not easy. I sat at the bargaining table multiple rounds, and it's very difficult. Like I said, anything that we want, any big battles, we have to bring over and over and over again in order to achieve. We've brought things forward for healthcare workers like ratios and discussions with this employer have been, and the employer has refused. But does that mean we stop? We don't stop. We continue bringing it forward until we get there eventually. And we have to continue pushing for these things. There's ways to get there, but it's hard-fought battles. The language in this agreement is there has been many hard-fought battles in there, and it's. And I think things will be different for smaller bargaining units? That's not what we're seeing in Hay River Health and Social Services, which, you know, we can debate who the true employer is in that case, but it's a healthcare unit only, and in order to keep up with what the GNW we've negotiated at the government of the Northwest Territories, they've had to serve strike notice in 2023 while they were evacuated, they have had to went very far into the bargaining process in order just to obtain what the government Northwest Territory had previously negotiated for the same years. So do we think it's going to be easier? It's going to be hard-fought battles. There is no doubt about it. Like we've seen with this government already, and in fact, like I said, we've seen that at HRHSSA, it's had its own set of challenges, like when we found out that I'm not going to quote the exact number because I don't want to misspeak, but over 90% of the bargaining unit was essential. So there are challenges. Is it done in other jurisdictions? Absolutely. It's done in the Northwest Territories with HRHSSA. But in what we have seen historically is that they have struggled to maintain what we have been able to negotiate with the government of the Northwest Territories.
Okay, thank you. Seeing no further comments from committee for round one, I'm just going to insert one question, and that is just, you know, you asserted that the certification needs to be done right. And I noted this in the presentation from the UNW as well, and wanted to ask you the same question. What MLAs have heard from nurses is that they tried extensive means within the current structures of the unions to have that conversation and met nothing but roadblocks. I'm just parroting back what they've told me. And so it sounds to me like they have come to you know, an MLA and requested, you know, that we've gotten to this place from a large amount of effort on their part to go through the right channels and do this right, as you are asserting, and they have not had any success doing so. So I wanted you to speak a bit to that on the record and the difficulties that they've had, because I don't get the impression that people saw this as a first step. It was brought to me and contextualized as a last resort. And so I guess the question I would ask on their behalf is, if they tried to do this the right way and kept being told no and kept being told it couldn't be done, and just met with opposition in various different ways, it seems to make sense to me that we got to where we are. So how do you respond to that, and what would you respond to? I guess a better question is, how are we going to deal with this issue going forward? You seem to feel there is a better way to do this. How do we get there?
Again, it's a big question. So speaking about the past, it's difficult for me to do because I have been outside of the UNW and more involved with the PSAC for now 2.5 years. So difficult to speak as to what has happened exactly over the last 2.5 years. That is UNW specific, or the conversations that may have happened there. I also have difficulty sort of identifying who's they, and the question that was posed, because I speak to many nurses, I work with them, there is definitely a group with strong will to see this come through, but there are a lot of people who don't feel that way. There are people who say, I just don't want to be involved in this discussion. There are people who have strong opinions of the other way. There's a spectrum of opinions on where people fall on this specific issue. But for those who have been pushing it forward, like I said, I've been outside of the UNW for 2.5 years now into this role at the PSAC. So I am uncertain of what discussions have happened. During my time on the UNW executive, this is not something that was brought forward during my time while I was sitting on the UNW executive. What I will say is that as PSAC Regional Executive Vice President, I have met with a few nurses who wanted to discuss this specific issue, and we discussed ways to try and get there. That was what we discussed. But again, a lot of these things, UNW is the bargaining agent. As a PSAC and somebody who's been elected to represent all of our members, I want to encourage members to push for the things that they are passionate about. And I was one that pushed for things that certain people weren't impressed with in some days in my time, and I'm not afraid to pick battles that are difficult sometimes to achieve, and trying to figure out ways to get there. So, whether I agree or not with things in principle, I did take time to have discussions with people who were interested in pursuing this and figuring out how internally we could sort of navigate things and try to push things forward. There was another half to your question. I'm sorry, Mr. Chair, but there was something else at the end, and I forget now what it was.
Yeah, of course. Pretty much what I was asking is, how do you envision the better path forward? And what are you going to do to drive that? Because I think, yeah, that was effectively it. Is you seem to feel that there's a better way to do this. Can you lay out for us how you might support that in your role? Thanks.
Like I said in my presentation, I think that the Minister of Finance and the government has engaged into the modernization of the Public Service Act. Phase 1 is close to completion, and hopefully we can, I'll speak about that draft sometime soon. But there is also Phase 2 that is coming, and a deeper look into Section 41. And I think, that the PSAC definitely wants to be involved into that discussion and be active participants in ensuring that they reflect the best interest of our members. And, we definitely, like I said, want to be involved into the process, and modernizing the Public Service Act as a whole, we think is the better way to get to somewhere where members feel that they are represented by a legislation that addresses their needs. I hope that answers your question.
Thank you very much.
Okay.
We'll move on to round 2 now for questions, and I have Mr. Hawkins up first.
Thank you, Mr. Chairman. I just want to, if it's possible, to lean into the experience or expertise of Ms. Blatt a little bit more on Section 6, brackets 3. I'm just curious, I'm not a negotiator. Well, I don't do very well at home, so I'm definitely not a negotiator most days. So, but in the sense of, I don't have these expertise, seeing how these things work. And what I'd like to ask is this, is that when I read the provision of section 6(3), it's this statement of assumption that, oh, don't worry, everything will be fine. You highlighted from your previous two sets of comments about the freezing mechanism isn't the same. You know, I remember once, and this is slightly a tangent, but it should make sense. I remember once when we were talking about devolution, and one of the former deputy ministers says, well, you know, it's in legislation until we get judicial guidance. It looks like this is the way it is, you know? And judicial guidance, where I chuckled probably for about 20 minutes thinking, yeah, till someone makes a final ruling if that's right or wrong. We're proceeding as if it's right. I read section 3 as just assuming everything's going to be fine. But I'm hearing you say it doesn't quite work that way. And I was then thinking, as I listened to you, thinking, isn't this a determination between the employer and the bargaining unit has to be negotiated? So you can't just assume I get these rights. And that's to me what it seems like section brackets 3 is this natural assumption, because I put it in the private members bill that, oh, everything will be the same. My question now is, it can't be unless the employer concedes no problem. Do you follow where I'm going with this? It seems to be it's a nuance, and it may not matter to anyone but people like you, but it seems like there's a weird nuance here. If Ms. Blatt had some thoughts on that, I'd really appreciate it. Thank you.
Thank you. Ms. Blatt?
Thank you. I think I've got the general thrust of what you're asking. I would say this. It is a freeze provision. I really don't think it can be read as anything but a freeze provision. And freeze provisions exist to protect the group of employees in the bargaining unit that is going to be negotiating either a first collective agreement or a renewal collective agreement. Typical labor legislation actually provides for two freezes, a certification freeze and a bargaining freeze. And there's a seamless transition between the two. When a newly certified union serves notice to bargain, they transition into the bargaining freeze. When they file the application for certification, the certification freeze is initiated. I kind of presented those backwards, but that's the chronology. The reason they exist is because history has shown, and contemporary ongoing experience has shown, that if you don't freeze the terms and conditions of employment during either the certification or the bargaining phase, employers will alter them, either to essentially bribe employees at the certification phase into not voting in favor of a union, or during the bargaining phase to increase their bargaining leverage. And so the legislation keeps that freeze in place until parties reach lawful strike or lockout position. So in the sense, the bill does serve, that provision of the bill, I think, will serve its protective function for the most part. There is a somewhat complicated caveat that I could offer to that, and I can elaborate on that, but I think the key thing here is it does not carry over the collective agreement. It puts 6.3, the new sub 3 of 41.04, it's like a combined certification freeze provision and bargaining freeze provision. It kind of does both at the same time. But it's very clear that if nurses have democratically, well, or even undemocratically, given the lack of controls in this bill, if a new bargaining agent is authorized, they will become a separate bargaining unit. The nurses' terms and conditions will be frozen, and they will remain frozen until they reach a first collective agreement. That actually keeps the freeze in place longer than the previous existing provisions of 41.04, which are more standard in that there's a point in a standard collective bargaining statute where the freeze comes off at the point of strike or lockout position, and the union can exert its right to strike, and the employer can exert its right to lock out or to change terms and conditions. They can say, well, now we're giving you all a raise, and that will maybe keep a lot of people from going on strike. Like the the purpose is to create stability in the bargaining process. And I fear I'm maybe straying from a clear and direct answer to your question. So maybe I should check in and see how I'm doing and whether I can clarify any of that.
Okay, thank you. Over to Mr. Hawkins again.
No, thank you. I think by all means you're being helpful. I mean, I'll let you correct if I'm missing the target on this one. But I mean, I get a sense of it's to ensure the ground doesn't crumble under people if they do this, but it doesn't present a guarantee of what the future will look like, and hence that has to be negotiated. But it's not a guaranteed base. So in other words, continuation until you have a new agreement. This isn't the base. This is about you're safe until something gets established formally and properly. So I'm assuming and reading it that way, but I also took the position, whereas in the curiosity, which is this bill is saying the GNWT is automatically guaranteed to, without being a signature to it, that they're extending conditions and agreements. To me, that seems a foggier concern. So I'll let you. I have one more question just in this round, and I'll if you wish to weigh in or correct on that particular one, I certainly wouldn't. I would certainly like to hear it. The other aspect is.
Oh, sorry. Would you like me to do that?
Not yet.
Or should I wait? Sorry. Okay. My apologies.
I don't know if you can see us, but no problem. Okay, so the other area, similar to our chair's position had asked, I just want to recap on just a couple minor items, which is I've heard since being reelected, I guess that's the way you're looking at it, it's from my sabbatical. Shift premiums, management issues and workload, like work ratios, etc. And I could go on about another 10 things, but I think that's enough for the conversation, is that these continue to be challenges. And we all know that the PSAC, unless something happens, the update will be coming this fall. And I think we're all familiar that the minister is willing to go into some type of discussions after that with the unions to work together to find out how to achieve goals better. Similar to your question about how do you achieve the ends. It sounds like the minister is willing to find ways to work to get more of these union issues, and I'm referring to new nursing issues, on the agenda, at least for conversation and different paths. Do you see an opportunity outside of the current Bill 26 of achieving these goals in the near future? And I don't think of it as a date as in 6 months or 6 weeks from now, but do you see that? Because the way I read the last letter from the minister is there was a willingness to find a way to work together on this in collaboration, hopefully to address these issues. Because Bill 26 in some ways I thought started off with the context of shift premiums were a problem, management issue was a problem, and workload ratios were a problem, but I don't see any of that being addressed in this bill. I see this as a breakaway and we'll figure it out. So do you see hope and opportunity in the future? I guess that's really what I'm getting at. And I only named 3 because I mean I could be naming 26 or 86 or 96. Thank you.
I take it that question is for Ms. Spirito.
And Ms. Blatt wants it fixed.
Quickly, I'll say that we have a great opportunity ahead of us as we are into bargaining now. Like we're starting the process. We haven't yet served notice to bargain, but we are really close to starting the process. They elected our bargaining team's name proposals. The majority of the things that the member named are negotiated things. So we have the perfect opportunity here to address some of these issues through the bargaining process. So yes, that's my hope, is that, I'm not quite familiar with the comments that he was referring to, but I'm definitely hoping that the employer is showing up to ensure that we are putting our best foot forward and negotiating language that will ensure recruitment and retention of highly qualified healthcare workers here in the Northwest Territories. And I speak highly. I think sometimes there are a lot of recruitment initiatives put forward and not enough about retention. So hopefully this is what the employer will come to negotiate this time around. Quickly on the other comment that was made right before the question about bargaining and a freeze versus a collective agreement, I'll just say that this whole concept of when we come to bargaining, even for the GNWT, it is true that none of this is a guaranteed. But I'll say this, the last time that our members saw a significant decrease in their benefits in their collective agreement was in the 90s. If I'm not mistaken, it was in 1995, where there was rollback and there was vacation travel allowances were removed and our members went backwards. And our members were clear that this was not going to happen again since. So although there is no guarantee that we will get everything that is in this collective agreement when we start a round of bargaining, our members have been prepared to fight and to ensure that, you know, when the conditions, the terms and conditions of employment are maintained through this collective agreement. And when we start a round of bargaining, we're amending the existing text. We are not bringing forward 120 new proposals in the form of a collective agreement. So just something that I wanted sort of to highlight the difference in between, you know, this is my proposals and it's a document of 225 pages and this is what I'm asking for versus I have 10 proposals that are our priorities and would like to achieve, and then we're negotiating with the employer.
Okay, thank you. It sounded like Ms. Blatt had some clarification to offer, so I'll give her an opportunity to speak.
Thank you. I'll have to ask the members' indulgence in just quickly restating the question, or I just want to be sure I'm responding specifically to the question that the member has. I mean, I'm happy to speak at length about the bill and the concerns and issues that it presents.
Mr. Hawkins, an opportunity to quickly clarify.
Yeah, thank you. And I appreciate that. If I remember my last round, I think I'm coming to this determination that this is about, I guess, the ground not crumbling. I was trying to emphasize it's not a guarantee of the future outcome. It's probably a base for conversation, but it's not a base for guarantees. That's what I was getting at. And I was thinking just to make sure that I clarify on what section 6(3). Thank you.
Is that clear, Ms. Blatt?
That was very clear. Thank you. I agree entirely. There is no guarantee. There is a guarantee that the terms and conditions will be frozen during the period in which a first collective agreement is negotiated. The content of that first collective agreement is wide open. There is no guarantee that the best things in the current collective agreement that were won over decades will be present in the first collective agreement for a nurse's separate bargaining unit. Whether they appear in that collective agreement is going to be a function of the resolve and the bargaining strength of the nurses themselves. I can say for my part, and I think I likely speak for my colleagues, I have serious doubt about their ability to achieve those things. If you will, there's a distinction between getting your issues to the table and achieving your issues at the table. A separate bargaining unit for nurses will greatly facilitate getting nurses' issues to the table. But I believe it will significantly diminish nurses' ability to achieve their goals at the table. I want to also add here that, you know, we've received the report of Mr. Reddy, which you've also received and hopefully will review because I think it is important. He has made recommendations. In the executive summary, recommendation number 4 is a recommendation to us, to the union. It's not a recommendation to the legislators or to the employer. It's telling the union, PSAC and UNW, that we need to enhance the representation of nurses. And he makes some specific recommendations on how we should do that. We're taking those on board. I would anticipate that they will be treated seriously and actioned. So my view, and maybe I haven't explained why I think nurses will not do as well or be at risk of not achieving their goals at the table under Bill 26. They'll get them to the table easier, but have a harder time achieving them because my understanding is they will be predominantly declared essential. Most of the nurses will have to continue working during a labor dispute. And the Public Service Act in its current antiquated form does not provide for access to interest arbitration. which is typical for essential groups of employees who are essential, that they go before a neutral arbitrator who crafts a new agreement for them. I think you would have a small number of nurses on the picket line trying to achieve things that they just won't be able to without access to the leverage of the threat of a strike. No union wants a strike, ever. Nobody wants it. But it is the ultimate form of leverage that this labor relations system provides. And I have serious concerns on behalf of nurses, but it's not my opinion on that matters, of course. I am not a nurse. Does that answer the question?
Okay, thank you, Ms. Blatt. Appreciate it. We are virtually out of time here. I do want to remind committee we have another public briefing at 3 o'clock and still need time for a break. So we are pretty much out of time. I do have one member, Denny, I'm going to have to, or Mr. Rogers, I'm sorry, 15 to 30 seconds at max for a very quick question. And then it'll be Ms. Spirito's last words because at that point we'll be out of time. So very quickly.
Thank you, Mr. Chair. I want to ask a question. I'll just make a quick comment. We're not selling widgets here. We're a government, obviously. We're not trying to make as much profit as we can off our widgets and do that on the backs of labor. We understand, and again, as I said earlier, we're trying to get to the same thing here. And, and I understand, yes, nurses may be able to bring that to the table and it may not, they may be able to get it to the table, but may not be able to achieve it. Well, again, we have a health system that we have to run as well. So I think it's a little different than in this situation where you're dealing with a government versus a manufacturer. And I guess that was my only point I was trying to make. I won't ask my question because I appreciate the time and I really appreciate you coming and presenting to us today. Thank you.
Thank you very much, Mr. Rogers, and I'll give Ms. Spirito the opportunity to respond to that in her final comments. Unfortunately, we are out of time. Committee will have the opportunity to debrief and ask questions in writing, of course, in follow-up if we have any further follow-up questions that haven't been covered today. But Ms. Spirito, I did want to give you the opportunity for closing comments before we close out. And respectfully, if you could be as brief as possible, we are out of time. Thank you.
Absolutely, Mr. Chair, and I do want the committee to be able to have a little bit of break before they run to their next meeting. I'll just say, I would also say that it's different when we're dealing with, healthcare systems and programs that are so critical to the people of the Northwest Territories that need a workforce in order to deliver it. Unfortunately, while sitting at the table with this employer, I can tell you that I still remember vividly the first time I sat at a table in front of this employer because I couldn't believe the disregard for the workforce that they were expressing in the comments that they were making. So sometimes it's difficult to feel that there's a feeling that maybe once we get to the table, how critical this workforce is not always appreciated. That's all I'll say on the comments. I really want to thank the committee for taking the time to hearing from me today. I understand it's been a very busy week for you, and I really appreciate your time and giving us the opportunity. We hope that you really take the time to read Mr. Reddy's report, and if you have any further questions, please, we are available. We would be happy to continue these conversations in other formats should it be necessary.
Okay, thank you very much. And on behalf of committee, I thank you for that offer, and certainly I think committee will probably take you up on it, and wanted to thank you for taking time to present to committee today. On behalf of committee, we really appreciate it. So for folks who are tuned in, that will conclude this public portion of the meeting, and we are back on at 3 o'clock with the Territorial Ombud. With that, we'll give committee a break and pause the briefing. Thank you.